Lawyers, what's your best, most badass, arrest my case moment? Story 1. I do mostly solicitor work, so if I'm doing my job right, I don't get a whole lot of these types of moments. That being said, I had a longtime client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, who we'll call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-complete or confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out, or he can find himself another job. He takes the latter option, but he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid. 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin in front of a judge that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Story 2. I represented a man in a slip-and-fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close, because it is a huge sloppy mess that involves using a garden hose after applying chemicals to remove all of the greases. The close-down process can take up to 2 to 3 hours that involve packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour's worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing, while there were still customers in the restaurant. This is really dangerous, as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook had to wear a plastic smock and slip-resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby tracking this stuff into a hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard that it causes a subdural hematoma, which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that, the cook was fired and the corporation claimed that they could not locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied that he was the one that tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before the trial because we were going to call him as a witness. He was pissed that they fired him. I asked, "Do you think they're still cleaning before closing? Because they are denying that they do." He told me, "Absolutely." On the first day of the trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing, to record video on a cell phone whether they were cleaning or not. Guess what? They had the hose out and everything. I couldn't believe that they would continue to do this at the restaurant at issue in the case. I told my investigator to go back up there when there is a different shift manager and cook to see if they're doing the same thing. They were. At the end of the trial, the defense put on their general manager for the region. He swore up and down that this never happens. It was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers, we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video with audio of the hose as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using a sub-rosa video against a defendant like this is very rare. They usually stop doing what they're not supposed to be doing during the trial. I guess the restaurant didn't get the memo. Story 3. Opposing counsel decided that I had coached my witness and given him lines to repeat, that he was lying. The short version is that he asked the witness if he spoke to me before he testified. The witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him and what instructions I gave him. Witness looked him dead in the eye and said, "First thing you told me was to tell the truth, no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me. If I lie, I'm on my own." Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. The only time I smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I am done with this guy." Story 4. I represented a company that was sued for breach of contract by a former independent contractor. The dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, the dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his debt. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Story 5. I was a second-year associate and handled my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely crappy examination of the issue. His expert report was equally as crappy. For those of you that don't know, expert testimony needs to meet a certain standard, the Daubert standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Daubert motion to strike his report or testimony because the case was low value, under $100,000, and those types of motions can be very complex, and don't want to bill a client for it. I was so angry about this guy being deemed an expert that I came in on a weekend on my own time and drafted a 20-page motion to strike his testimony. I didn't bill a client a dime. The defendant didn't file a response to my Daubert motion to strike. Instead, they waited until night before the expert was set to testify. I'd been sitting on court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of the expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart in the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible but not quite as terrible. They also did his cross-exam. Realizing that they were in serious trouble without their primary expert and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck except for one very, very tiny area. So essentially, he was forced to testify with both hands tied behind his back. It was the most gratifying moment in my legal career so far. Story 6. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in a courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties about a short trial that was to be heard after our motion was argued. That matter was also a professional negligence matter, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I revealed in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 7. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spiring chicken himself, and seemed skeptical when he asked exactly how my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92 and the case has already gone on for 5 years, the judge was visibly shocked and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. Story 8. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me. Did you or did you not pay into the state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. Sir, answer the question. Silence. Mediator. Well, let me ask it. Did you or did you not pay into the state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. I'll take that as a no. Story 9. Complaining witness accused my client of harassment and stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, and wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. The girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. "This is Mr. So-and-so, right?" "Yes." "In this photo, he's on a bed." "Yes." "The bed is yours?" "Yes." "The bed is in your bedroom?" "Yes." "You took this photo of him?" "Yes." "He's smiling in this photo?" "Yes." "And in this photo, he's wearing your brassiere?" "Yes." "No further questions, Your Honor." Story 10. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said, "Yes." In England, we don't say, "I rest my case." Instead, I looked up at the bench, said, "No further questions," and sat down. It might not seem bad, but I got the defendant to admit the offense with one question. That never happens. Story 11. It wasn't a trial, so we had one of those and I won it easily. It just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, and came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture-type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks, i.e. the notes he took during class. He is furious and sues the landlord in small claims for $5,000, state maximum, because his notebooks have such huge value apparently. They hire me and I respond, which moves the case out of small claims. It's just the way it works here after time. I know this is not the case for every state, but our rule is better than yours, but enough aside. This puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, "No, that won't be happening," and direct her attention to a particular state statute and then read it out loud to her. This statute, like everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned. Period. End of the story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. Story 12. I helped the prosecution rest this case. Well, I got jammed up during spring break doing dumb spring break stuff. So there I was in court to face the music, misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating that the potential max sentence was for each or all. I didn't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said not guilty, and I could see that both the judge and prosecutor were getting tired of the crap. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this, "Let's just get it out of the way, tell us you're not guilty" look, and asked how I pled. "Guilty, Your Honor." The judge and the prosecutor both looked at each other and the judge said, "Kid you not." "Say again?" Or, "Beg your pardon?" "Guilty, Your Honor. I did it, just the way Officer So-and-so's report reads." They exchanged looks again and the prosecutor held his papers at arm's length as if to get a better look at them and did the unthinkable. "Your Honor, this all reads to me like a case of a college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time and walked out paying like $110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones. Story 13. Two high school kids spend their day pissing each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely and solidly across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking in they had two former employees testifying about large crowds building up after school. The plaintiff's attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have armed guards in the parking lot. At best, the witnesses wildly exaggerated to the point of perjury. Their credibility was shaky, being highly disgruntled for being fired, who had a list of witnesses ready to refute their claims. At trial, the plaintiff's attorney presented first. He spent a long time building up the bad blood between the kids, the serious damage to Kid B, and his potential learning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation the restaurant was safe. So, when we reconvened, defense rests, Your Honor. The plaintiff's attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, "I take it you will need a few minutes for your close?" After that break, the plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury, Kid B is 10% at fault. Kid A, 90% at fault. Restaurant, 0%. Story 14. I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and wind so strong that the defendant could only open his window 3 inches, and that the car had stopped in an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified that he smelled a strong smell of alcohol in the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol in the breath of someone on the other side of the car. Through a 3-inch crack in the window on a night with pouring rain and strong winds, the cop sort of opened and shut his mouth a few times, squirmed around in his seat and said, "That's just what I always write in my log, to remind me that it was a DUI stop." The judge threw the case out, no motion to dismiss is needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice pot of tea and some scones. Story 15. Corporate lawyer, but this was on a pro bono housing matter. My client just needed to not lose her housing. I was trying to get her on 1-year probation, but would agree to 2, instead of termination. The day of the hearing, I had 6 summer associates come with me, each carrying huge binders. When my hearing was about to begin, I had them all bring them in and sit them in front of me. The opposing lawyer was a very overworked NYC housing attorney who had budgeted an hour that day of my hearing. She instantly goes, "What is this?" I told her it was my argument. She said she didn't have the time. I started off on a 2-minute opening I had prepared, then grabbed one of the binders and she was like, "Let me stop you there. What do you want?" I said 3 months probation, but she countered with a year and ended up agreeing on 6 months. The binders were all empty. Story 16. My client and his wife were woken up one night because people were trying to break into his house. He fired 2 warning shots as his wife called 911. The neighbor also called 911. The police got the neighbor's call that there were shots fired. The police sergeant radioed the other officers and said, "He's going to jail tonight," referring to my client. So obviously, even with signs of someone trying to break in and his wife calling 911 for help, the officer arrests my client for endangering his wife by shooting inside the house, nowhere near her. It gets to a jury trial and I start to go off on the police sergeant about why she would say that before an investigation and before she even had any idea what happened. The sergeant had no idea how to respond and literally just sat there staring at me for a solid 2 minutes before saying anything. Even the bailiffs were audibly laughing. Story 17. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict with motion hearings as little conflicts. The opposing attorney was insisting that Rule A meant that they could do X. I tried multiple times to point out that Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney and said, "Show me where Rule A says X." The other attorney did not take the hint, read the rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add. It was pretty fun." Story 18. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with a judge, who asked the driver if he had ever sped before. "No, Your Honor, I never speed," was his reply. The judge asked him a couple more times if he was sure if he never sped. Ever? The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding." The driver had to pay medical bills for my sister. Story 19. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. Story 20. When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since the opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot and I ended up with an A.